Welcome to another episode of Law and Order. As you all know, this is a program where we provide answers for your legal issues pertaining to different topics that may be timely important. And today also we are going to deal with one of the most important topics, and we are going to discuss about criminal law. And to do the honors, we have a well-deserved person to discuss about this topic, a great personality in the field of law, President's Counsel, Mr. Sarat Jaman. He was the former Senior Additional Solicitor General. Good evening to you, sir.
Good evening, Charit.
And it's nice to have you with us for this discussion. Right. Okay. So basically, when we discuss criminal law, most people are afraid to discuss, but it is one of the most important topics that we need to know. As you all know, not knowing law is not an excuse. So you all have to be aware about these legal issues and certain facts which are mandatory as an individual for you all to be aware. So basically, let's approach to the topic, and we are going to discuss something diverse and which are very important for you all to know as a citizen in the country. So simply moving on to the topic, so we'll expose what is criminal law.
Criminal law, especially if you watch TV and other media these days, you know there are certain crimes that have been committed against human beings, maybe physically or maybe to their property. And those things have been defined as a conduct that is not accepted. We have a basic criminal law written in the Code of Penal Code. This was given to us by the British in the year 1883. Basically, criminal law describes the nature of the penal offences, from the offence of theft, the robbery, murder, rape, child abuse, criminal misappropriation, cheating, etc. So those are considered as criminal offences. When you have a criminal offence committed against a citizen of this country, what are you going to do? It is up to the state to launch a criminal investigation. After launching a criminal investigation, if there is sufficient evidence against a particular person, then you have to go before the court and conduct a prosecution. Once the prosecution is conducted, the court will see whether the prosecution has proved the case beyond reasonable doubt. If the court believes the prosecution has proved the case beyond reasonable doubt, the accused is convicted. So once the accused is convicted, a sentence would be visited, sometimes a jail sentence. Now the whole purpose of the criminal law is to punish the perpetrator. Why? In the philosophy of criminal justice, it is assumed whenever the perpetrator is punished, it will be a deterrent to the society.
Right.
Further, this particular perpetrator is incapacitated, so he may not be able to commit another crime during a particular period.
Right.
The other theory is when one does a wrong thing, you must take a revenge. So that is called theory of retribution. But in this context, we see that there is hardly any pivotal role a victim can play. Victim interests are not to that extent is watched or looked after. Right. So that is why in nowadays there is a new act called Victim Witness Protection Act.
Right.
Generally we focus on the accused and how he should be treated, how he should be punished. But the modern thinking is not only the accused should be punished, we must see that the victim is given a particular right and how the victim should be given a compensation and how his concern should be addressed.
Right.
So that is the basic purpose of criminal law, and it is the duty of the state to conduct a prosecution, because in the eyes of law, everyone is presumed to be innocent.
Right. So as that presumption of innocence, and when we take about the role of the state, so can we just deeply move on to the role of a state, because you are the former Senior Solicitor General, so you have that capacity working in many landmark cases as well. So can we define the role of the state?
Yes, we know the sovereignty is with the people. When it comes to legislative sovereignty, it is with the parliament. When it comes to the sovereignty of the executive, it is with the president and the cabinet. then people's judicial power is with the judiciary. Now, when something happens to a citizens of this country, the state is required to do certain things. When you say state, there are different organs. For example, if there's a criminal offense is committed against someone, first step is to conduct investigation. Generally, that task is given to the police. Thereafter, what happens once the investigations are over, a magistrate will have to take a decision whether the suspect should be prosecuted in the magistrate court. If it is a serious offense, after the conduct of the investigations, police must seek the advice of the Attorney General. If the Attorney General thinks there is sufficient evidence, what will happen? Attorney General will send out an indictment to High Court, then he will send his officers to High Court and do the prosecution. Then there is a third actor also. The third actor is the judge. Judge is not involved in the investigation. Judge is not involved in the prosecution. He is there as a judge to see that there is a particular presumption. Under Article 13 of the Constitution, everyone is presumed to be innocent. So then, judge will look at whether the prosecution has proved the case beyond reasonable doubt. The prosecution is not allowed to lead each and everything the police have collected during the course of the investigation. There is an act called Evidence Ordinance. Evidence Ordinance will guide you what sort of evidence is legally admissible, what sort of evidence is allowed to be led in a court of law.
That means whatever we find as evidence or we think that this is fit for this case might not be suitable. Right.
So then judge will filter those admissibility evidence, and then he will come to the conclusion whether the accused has been convicted. Then he is the third actor. Then there is a fourth actor also. If the judge decides, now criminal offence has been committed, proved, then he will impose a sentence. The sentence will be implemented by the prison authorities. The main purpose is, all these actors are part of the criminal justice system. And there should not be an overlap. Why? If there is any overlap, there may be a conflict of interest. The investigator is not given the power to do the prosecution in the High Court. Similarly, prosecutor is not given the power to conduct the investigation. The judge is not given the power to conduct investigation. Why all these different entities are set up? Because to maintain the fairness. In colloquial language we say fairness, but in legal terms we say fair trial. Fair trial is very important. Why? Every accused is entitled to be tried before during a fair procedure. So later we'll take an example and discuss these things.
So when it comes to a certain case, for an example, think I have committed or I'm affected with a certain crime, and I need to proceed with a legal case, or I need to have a fair trial. I don't have anything. That means a lack of evidence. So how does the evidence play a prominent role there?
Because during the course of the investigation, the complainant might go and give a statement. We'll take an example.
Sure.
We'll take a case of robbery. We'll assume that my house is robbed. Two persons enters into my house, and one person is armed with a knife, another person is armed with a gun. Then by force they open the door in the night. They come and they threaten us, they threaten to kill us. Then by force they enter into our bedroom, open our almirah and take the jewelry of one of my sisters. And thereafter, in the meantime, to threaten them, they shoot in the air. Take the jewelry and these two persons go away. Then what will happen? What is expected from us? We have to go to the police station and lodge a complaint.
So if we have experienced such a thing, a theft or a robbery, we just first need to go to the police and lodge a complaint. Okay.
Now, when a complaint is lodged, the OIC officer in charge of the police station
Right.
will first examine whether this is a criminal offense. Naturally, when this particular jewelry is in my possession, it was taken out from me without my consent. On top of that, it was taken out by using the threat and using a weapon. Definitely on the face of it, it is a criminal offense of robbery. So when it is apparent it's a criminal offense of robbery, the OIC is entitled and OIC is required by law conduct an investigation. What is the purpose of investigation? The purpose of the investigation to collect evidence and find out the perpetrators. I have to tell you, during the course of the evidence investigation, they will collect evidence, but whatever written in the police books, it is not evidence. But whoever gave a statement to the police, they will be required during the trial to come before the court, get into the witness box and give evidence. So then what is the purpose of recording these things? Because if you don't record statement, what will happen? If you bring the witness straight away to court, the witness can say anything. So therefore, no sooner an incident happen, you have to go to the police station and lodge a complaint. Now in this instance, once the complaint is lodged, OIC will send a team. They will closely examine this crime scene. They will find these empty cartridges. They will find. They will try to find out the fingerprint. Then in the meantime, they have eyewitnesses. No, if I was in my house or my sister was in house, we are called eyewitnesses. We have to give statements. In my statements, I have to say the features of these two perpetrators. Assume that we know one of these persons previously. If I know the name of the perpetrator, you have to say. If we don't know the identity of this particular perpetrator, still you have to give the features. So then what happened? Police will have to go and look for other evidence, maybe from the CCTV in the neighborhood, maybe from other information. Then what will happen? They are entitled to arrest a suspect. But before arrest these two perpetrators, police must be satisfied that there is a credible evidence against those two persons. Without any evidence, without any material, if you arrest, what will happen? It is an illegal arrest. They can challenge those arrests before the Supreme Court by way of a fundamental rights application. So once they are arrested, what will happen? For example, in this case, at least one person is unknown to the witnesses. Then police are expected to have an identification parade where this particular perpetrator is covered, taken before the magistrate and make a request before the magistrate on a future day to hold and parade. So this particular suspect is remanded. After 1 week or 2 weeks, suspect is brought from the prison fully covered. Then he will put among 6 other persons. Then these 2 witnesses will be summoned. Then you have to identify this person. You have to identify this person. If identifies, fine, that is good evidence. If you don't identify, very likely there won't be a case against him. Then,
so interrupting in the middle, sir, if an identification parade is conducted, suppose that the real person who committed the crime is there, but unfortunately, if I'm the person suffering from that, I can't identify him because of the bad light or during the situation of the day, I can't identify him. So will that be a certain fact to release that suspect?
Certainly, because if the person is not identified, if you don't have any other evidence like fingerprint or CCTV or any other evidence, what will happen? Since there is no evidence, that suspect has to be discharged. Certainly that suspect has to be discharged. Then now in this crime scene, what happened? There were some empty cartridges also. Then what will happen? The police officers collect these empty cartridges. We'll assume during the course of the investigation, a particular gun is recovered from the possession of a suspect. Then what will happen? that gun along with these empty cartridges will be sent to an expert. He is the ballistic expert who serves in the government analyst department. He can examine the empty cartridge and say whether these empty cartridges were fired from the gun that was recovered from the possession of the perpetrator. That is very good evidence. That means this gun was used during the crime. Now this gun now is in possession of the suspect. So that is a very strong evidence. Unless suspect says, of course gun does not belong to me, it was given to me by some person yesterday, I know the person who gave the gun, he must be having explanation. What is most important thing is, in a criminal investigation, the suspect has to be told what he has done. Then suspect statement has to be recorded. It is a must. If you don't record the statement from the suspect, there is no fair investigation. Because every crime, suspect must have an explanation. No? We'll assume when suspect is given this opportunity, he confesses to the police officer. Now when you confess, that is good evidence. But in the eyes of law and the criminal evidence ordinance, which was enacted in the year 1894 by the British, clearly says a confession made to a police officer is not evidence. So therefore, if you watch TV, during the news break, the investigator might come and say, we have solved the crime, we have resolved the crime because suspect has made a confession. That is not evidence. Why that is not evidence? Because in India also same evidence ordinance is there. Sir James Fitz Stevens, he is the architect of the Indian ordinance and the Sri Lankan evidence ordinance. They thought that countries like India and Sri Lanka, we can't rely on the conduct of the police officers. That is why by law it says, if you make a confession to a police officer, it is not admissible. Thereafter what happened? Now this confession is there, it is not admissible. We'll assume this jewellery, robbed jewellery is now recovered from one of the perpetrators. Now when you recover jewellery, what is expected from the police officers? We do not know whether this particular jewellery belonged to the robbery of my house. So then what will happen? During the course of the investigation, you have to show the jewellery to the witnesses. They have to identify. So once investigations are done like this, then what will happen? Now they have gathered the material, they have conducted the investigations, then you have to submit a report. Before that, no sooner suspect is arrested, within 24 hours, suspect has to be produced before the magistrate. You can't keep a suspect in the police custody more than 24 hours. And thereafter, if you want the suspect to be remanded, you have to satisfy the magistrate. You have to send a report. You have to give a synopsis of the evidence to the magistrate. Then the magistrate can remand the suspect only for 14 days. Then after 14 days, suspect is brought again. And if you need another for 14 days, he can be remanded. So once the investigations are over, what will happen? Police have to file a report before the magistrate and give a synopsis of the evidence. Then police must say, we are instituting proceedings. Then magistrate must look at the evidence. Then it is the duty of the magistrate to frame the charge. Before framing the charge, magistrate must see whether the investigations have been conducted in a fair manner. And whether there is sufficient evidence. If there is sufficient evidence and if it touches the ingredients of the offence, what will happen? Magistrate will frame the charge. And if it is a serious offence, serious robbery case, magistrate will send the case to ask the police to send the case to the attorney general. That is what happens.
இந்த மழலையின் குரல் உங்களோட வீட்டுல கேட்கலையா? குழந்தையின்மை தொடர்பான பிரச்சனைகளை சந்திக்கக்கூடிய அன்பான உறவுகளுக்கு ஒரு செய்தியை சொல்ல போறோம்.
வணக்கம்.
குழந்தை இல்லாத தம்பதியர்களுக்கான சிறப்பு நிகழ்ச்சி டாக்டர் அருணாவுடன் ஒவ்வொரு ஞாயிற்றுக்கிழமையும் காலை 11 மணிக்கு உங்கள் நேத்ரா தொலைக்காட்சியில் காணத் தவறாதீர்கள். பண்டாரவளை ஸ்ரீ சிவபத்ரகாளியம்மன் ஆலய பிரதம குரு சிவஸ்ரீ சர்மா சுவாமிகள் கலந்து சிறப்பிக்கும் பாண்டவ ஜோதிட ஆன்மீக விளக்கம் சம்பந்தமான நிகழ்ச்சி ஞாயிறு தோறும் காலை 9 மணிக்கு உங்கள் நேத்ரா அலைவரிசையில்.
So evidence play a major role there. Without evidence, nothing can happen. So as we're running out of time and we're coming to the end of the program, we discussed what is the role of the state when it comes to a certain thing, a certain offense, and how we proceed forward in a certain manner, that we need to prove the case beyond reasonable doubt, and what is the purpose of the police and how they act. So there's another point. For an example, I have seen the real situation, what has happened there. For example, a crime is being committed somewhere else, might be a robbery, might be a murder case or whatsoever. The general public is afraid to give evidence, thinking that they will be in burden, they will be in trouble, saying that if I'm supposed to give certain evidence in front of the court, I have to, because if the court summons, we need to be there, we need to give evidence. So in certain cases, general public refrain from letting the other people know that they know this particular thing. So it might be a big harm, not for us, but for the person who is suffering. Like in that case, what is the advice as a lecturer in evidence and criminal procedure? What is the advice that you can give to the general public with regard to that giving evidence?
Because we have a social duty. If we are a witness to the crime, we owe a duty to make a statement to the police. You can't straight away go to the courts. First, you must make a statement to the police, and thereafter you will be summoned by the courts. Thereafter, you must go before the courts and give evidence. Because unlike in the good olden days, we have a special act called Victim and Witness Protection Act. And from that act, there are certain protections that are given to the victims and witnesses as well. So if there is any kind of influence, threat or promise, there's a special division in the police department. They will take care of these witnesses and they will try to give a protection. And if the witnesses are harassed, that is also a criminal offense.
Right.
And the perpetrator will have to face for another case. So therefore, unlike in the good olden days, now there's a Victim and Witness Protection Act, and every citizen must come and give support to the criminal justice system. Ultimately, you are protected. Because if you don't give a statement, what will happen? There is no evidence. Even if you give a statement to the police, that is not evidence, you have to come before the court. Just because you come before the court is not going to believe you. Court will test how soon after the incident that you have given evidence. Then court will test, though you say a particular version now in court, whether there are contradictory positions that you have taken during your statement to the police.
Right.
Then the the court will look at how probable your story. Then court will look at how you give evidence in court, your manner. Because when you lie, there are certain facial and body expressions. The learned, experienced judges can track those things. So then court will look at whether you are an impartial witness. Due to some impartiality, you are giving evidence for the prosecution or defense. Right. So judge will use all these tests and decide whether you are a credible witness. If you are a credible witness, then court will decide whether you have given evidence to the satisfaction that the case has been proved beyond reasonable doubt. What is beyond reasonable doubt means? Without a reasonable doubt.
Right.
In a civil case, you have to prove a case on a balance of probability. Like a 50%. But in a criminal case, I don't say 100%,
yes,
but maybe close to the 100%, you have to prove the case. Because if there is a reasonable doubt, the benefit will go to the accused. The reason is, if you give false evidence and if you send an innocent man to jail, it is a great injustice. That is why in criminal cases, you have to prove the case beyond reasonable doubt.
Yeah. Right. Okay. So we had a pleasant discussion about criminal law, how it applies to the society, and when taking an offense of robbery, theft, and how it commits, and the proceedings that we should take forward in order to prove it beyond reasonable doubt and to save the rights and everything. So as you all know, the Law and Order program focuses on these issues, certain facts that you need to know, and the legal issues pertaining to certain facts we are discussing. So today we were able to discuss basic things of criminal law and certain important areas, and even we highlighted the social responsibility of each and every individual when it comes to a crime. So thank you very much, sir. Mr. Sarat Jamana, President's Counsel, former Senior Additional Solicitor General and a lecturer in evidence and criminal procedure, and a well-deserved person to discuss on this matter of criminal law. So thank you very much once again for joining with us, Law and Order program, and thanking you all for watching the Law and Order program.
Thank you very much, Charit, for giving me this valuable opportunity.
Right, thank you very much, sir. And let's tune in for more information, and and even you can experience more legal issues and even certain answers for your solutions. Have a pleasant day. Take care.